All right. Good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner with a special guest over here, Tony Pellegrino. How you doing, brother Tony?
What's up, brother? Good to
Yeah.
have. Thanks for having me on, bro.
I'm glad to have you on, bro. Anytime. You know that. I know that you're a busy man, so it's kind of hard to get a hold of you sometimes.
Yeah, I don't know how you can fit everything you do in a day. There just isn't enough time and isn't enough competent help to do all this stuff.
I keep praying for 36-hour days. Maybe we need more people praying for 36-hour days so I get more done in a day.
Well, it's the Bible says in the last days the days will be shortened, so that's what I'm chalking it up to.
Not less time, more time. Well, it is what it is, right?
Yeah.
All right, so kind of let this populate a little bit here and see where everybody's at. I'm pretty sure. Well, wait a minute. Is it live on Telegram? Diesel D's, okay. Confirmation on Facebook, CC, YouTube. All right.
YouTube. I don't see you on YouTube. Are you on?
Yeah,
there
YouTube.
Okay.
Thank you, brother Diesel. He says happy to see us together here. I'm happy to have you. I know it's again just both of us are busy. Can somebody over on Telegram confirm in the please make your comments for the live here tonight that it is live over there? I am not live on Telegram. Oh, son of a gun. Oh, you know what? Let's see if it'll pull it in. Let's see if it'll... There it is. I actually have to start it type thing. Let's see if it'll... There it is. I actually have to start it type thing. And then how do I... There it is. I actually have to start it type thing. Okay. Forgot that I gotta prep it on Telegram as well. Usually Streamlabs, the way it works, it does it all by itself. It does the Facebook, the YouTube, and my Rumble. Although the Rumble I have to get the stream key. But I guess I gotta start it up on Telegram. That's all a new thing for me. This is second time I've done it here. This way. You used to do it, just start it up on Telegram and then share screen, and Telegram was just broadcasting by itself. So, all right, so that should be, yeah, it says live stream started, and I already cut that out. All right, thank you for the feedback on Telegram, Deanna Patriot and Tiger. I see you over there. Jax, Karen. How are you? The other Karen. Chad out on Facebook. Thank you, brother. Let's see. Kat on YouTube. Silver Love. That's a new one, I think. James, I recognize you out there on YouTube. So you ready for some exciting banter here tonight? We're going to break out the pugil sticks and equip you folks with pugil sticks so you can start beating the crap out of these people who want to trespass. Let's get the proper verbiage here. Common law trespass. Okay, our rights are from the common law. American Jurisprudence, Volume 16, Constitutional Law, Section 100. Bills of rights, plural, and those merely declaratory of the common law. Those Constitution provisions are mandatory. They stand on higher plane than statutes. Again, they are mandatory. So when our right dictates a certain thing or a certain process, it is mandatory. There is no, that you want to talk about mandates, those are real mandatory things. And we'll clarify the word mandate actually comes from the writ of mandamus. So when anybody tries to tell you out there that, oh, well, it's a mandate, show me the judicial mandate. And then,
As long as you're not talking about trannies, I like mandates.
I was gonna say the other aspect of mandate is when the Obamas go see a movie or two guys go fishing. That's a mandate.
I prefer a woman date. Go ahead. Sorry to interrupt. I couldn't help myself.
Yeah, no worries. You're all good, bro. The thing is about the writ of mandamus is from the judicial branch to a lower court, right? To instruct them to either do this or not do that. More specifically, the writ of prohibition is about the lack of jurisdiction type thing, but the mandate is for them to do something. Or the writ of mandamus can be used against the executive branch, a public servant, to instruct them to do this certain thing or to not do that certain thing. So, anybody tries to tell you, oh, well, it's a mandate. No. Now you know, because this is, knowledge. Knowledge is power. You don't have this knowledge, you ain't got no power. So let's get equipped with some knowledge so we can be literally empowered. I can speak from my own personal experience, and I'm sure that Tony can as well. As this knowledge, when you speak the law, as the Bible would say, our tongues are sharper than a double-edged sword. So when you speak it, it cuts them down. I mean, I personally have experienced it in front of Idaho State Police, the 80 county sheriff's deputies. They just get this deer in the headlights look, and I've had them scatter from me because I'm speaking real law, and they're like, "Holy crap! I don't want none of this guy. I'm out of here." Okay, and I've had witnesses standing around who witnessed literally these cops just scatter. They want to get away from me because they know I know, and then they know that I know that they know that I know. So this is where we need to get, folks, and we need to bring some serious unity. We need to bring the people together. The people need to come together. And we have to, a lot of people talk about standing together, but standing is a cause of action, not literally standing on your feet, standing on the sidewalk. We need to be taking some serious actions, and those actions need to follow the letter of the law, due process of law. And where a right, again, back to them rights, when the right dictates the process, it is mandatory. So the right of petition specifically states that we have the right to peaceably assemble, to consult for our common good, and to instruct our representatives and petition the legislature for the redress of grievances. Now, a petition has a prayer for relief. In a sense, it is a political lawsuit in the legislative branch, just like a Title 42, 1983 petition in the judicial branch. But it goes to the legislative branch. Okay? We have to learn about the different powers and functions of our three distinct branches of government. We have that separation of powers doctrine for a reason. And when one branch holds that specific power, it cannot be exercised by either of the other two. At all. Ever. And so, when we learn the powers of our three distinct branches of government, and we start exercising our political power in the legislature, that's how we and where we alter, reform, or abolish anything at any time we deem it necessary. But we need the majority of the people to be on board with this. Now, there are certain ways that we can do an initiative, right? We can make our own statutes. We can even do proposed amendments to the Constitution and submit it to a vote to the people, and the people vote on. This is where we get the majority to come in. So,
Can I share the last time something epic like that happened in California? What you're talking about, initiative?
absolutely. What do you got over there, brother?
So it was back in 1992. This was an old one. It was back, no, 94 and 95. Somebody the people got together, put together an initiative. Here it was called Proposition 8 in like early 90s in California. And Proposition 8 basically says the definition of marriages is the union between a man and a woman, period.
Okay.
And so that's when the governor came out, the Schwarzenegger. So it's a big controversy. Hey, Arnold, what do you think about this Proposition 8? What happens if it gets voted in? And he goes, well, I'm going to let the people decide, is what he said, initially, just because it sounded politically expedient and correct for him, because he was running for governor. But then he got in there. So anyways, it was the Mormon church that sponsored that. And just to show you the power of unity, Kirk, that all the churches actually got together and agreed on something. I mean, can you imagine that? And instead of arguing about their doctrine or who's right or who's wrong and, watching the South Park over it. But anyways, so what happens is it gets voted in. And to this day, it's still in the California state constitution. That's they squeezed it in between Section 7 and Section 8 in Article 1. It's Article 1, 7.5. Marriage is a union between a man and a woman. Now, even though the judiciary came in and said, well, no, we disagree with that, here in California, that case law doesn't overturn that. I mean, there's a little footnote that it's there, but it's in the California state constitution.
Now, this is where we have to, right there. This is actually good. This is great. The judicial branch is to be bound by the Constitution to support it. See, we've all been led to believe they've taken this power that was never been granted to interpret. They say that we have the power to interpret the law. No, you're supposed to support the law, and you're supposed to interpret whether or not the legislature has exceeded its authority or the executive has exceeded its authority, providing oversight, and declare that unlawful or unconstitutional. Because see, here's the key to all of this. Let me see what I got here. I'll pull up my American Jurisprudence, Volume 16, Constitutional Law. We'll start with Section 1. Oh, what did we do here? There we go. And see, that you need to know this stuff, because if it ever has, like in a situation there where it goes to the judicial branch, you make the law that the Constitution stands on a higher plane than statutes, right, and it's mandatory. But listen to what American jurisprudence actually says here. Get this sucker pulled up, because this you got to have this knowledge, Come on, baby. Word. Here we go. I'll share my screen. Now this is, again, Constitutional Law, Volume 16 of American Jurisprudence, 2nd edition. Section 1, the very beginning, and this is the last time I was down there at the Law Library. No, I guess it wouldn't be the last time I was down there. But when I pulled this was back in August of 2017. So this is fairly new stuff. This isn't, this is the actual American jurisprudence here. Okay? This isn't just some quotation from somewhere I pulled off the internet. So definition and nature of Constitution and constitutional law. So what is a constitution? A constitution, as used herein, the word constitution means a declaration of fundamental laws or principles for the government of a nation or state. It's for the government. It's the instrument of government. A constitution represents the what? supreme written will of the people regarding the framework for their government. Where a constitution asserts a certain right or lays down a certain principle of law or procedure, it speaks for the entire people as their supreme law, and it is the paramount authority for all that is done in pursuance of its provisions. A constitution thus embodies fundamental values and articulates the citizens' common aspirations, and it should be people's common aspirations for constitutional governance and the what? Rule of law. A state constitution is likewise the supreme written will of the people of a state regarding the framework for their government and is subject to only the limitations found in the federal constitution. Although a constitution may be either written, as in the case of the United States, or unwritten, as in the case of Great Britain, the word constitution, as applied to the organization of our federal and state governments, always implies a written document, because it's a contract, which is understood to have been enacted by the direct action of the people, providing for the form of their government and what? Defining the powers of the several departments within it, thus creating a fundamental law. Now, pay attention here, folks, which is absolute and unalterable, except through amendment by the people from which it emanated. See,
sounds like mandatory language to me.
They do not get to alter the Constitution. This goes back to the Law of Nations, Book 1, Chapter 1, Section 34. The question was asked, does the legislative branch have the authority to alter the fundamental law of the Constitution? And the answer is no, because it's the laws of its creation. And it's created by the people, not the servants. The servants cannot alter the laws of its own creation. So, the judicial branch is to, what? Make sure that the absolute rule of law stands, and that anything that comes in conflict with it is void for any effect. And to declare that unlawful and unconstitutional. Not, oh, well, we don't, no, because see, we could do gay marriage and that, no. Because what is marriage, brother?
Can I read this statute again?
Isn't marriage a sacred vow between a man and a woman unto God till death do them part?
That's where the first definition is in the Bible.
So, didn't God create marriage? God is the sovereign. He's the one that created it. It's even outside of our Constitution. We don't even have the power.
So why do people go to the government and ask for the privilege and an application and a license to get married? Isn't that foolish?
Yeah, wouldn't that violate the power there, the right? That there shall be no law establishing religion or the free exercise thereof. Marriage is actually a religious act. It's an action.
Well, Jesus says, give unto Caesar what belongs to Caesar, but give unto God what belongs to God. Getting a marriage license is given unto Caesar what belongs to God.
Yeah. Go ahead and read that. Now, was this a statute or was this a constitutional amendment?
There was Section 7 and Section 8, and they shoved it in. California State Constitution, Section 7.5, only marriage between a man and a woman is valid or recognized in California. That is it. And it says, section adopted from November 4th it's a 2008 initiative measure. I thought it was in the mid-90s. So there it is. The people put forth the initiative, and then it went to a vote. I mean, just like you said, that's how it's done. Yep. And people think, well, what can I do? Well, get some initiatives going on here.
Yeah. And here's the thing is, you can't license a right. And so here it is in Idaho Constitution right here. Article 3, Legislative Department, Section 28. Marriage. A marriage between a man and a woman is the only domestic legal union that shall be valid or recognized in this state.
Pretty similar.
Okay. It should be over under Article 1, Declaration of Rights.
Yeah, that's where it is in California under Article 1.
Right. So that's actually more proper over there. So the thing is, when we get into real law here, law of the land, the common law of the land, that's what the law of land is the common law of the land. Because this is the law that's common to all that are bound by it. And law of the land is due process of law. Literally means due process of law. They're synonymous. So when we look at rights as the law, comes from the French word droit, meaning right or law. Black's Law Dictionary, 4th edition, says law is that which is laid down, ordained, or established. Okay, so if you folks remember, 2 weeks ago, and we were supposed to kind of do this last week in connection with that previous video, so I've already laid down the law stuff on this, but I'm going to quickly go over this again. Is that these are rights of man, right? All men are by nature. So that's the laws of nature are free and equal and supposed to be independent, and have certain unalienable, not inalienable, rights, among which are enjoined defending life and liberty, acquiring and possessing and protecting property, pursuing happiness and securing safety. Oh, that's right. We have that right from the laws of nature. Let's refer back to that recent Supreme Court ruling in the Bruin case about the Second Amendment, that the right of self-defense comes from the laws of nature. And we all have the right to keep and bear arms, which shall not be infringed, because that right comes from the laws of nature. That's a body of law. Okay? So that's higher, because like the Declaration of Independence reads that to secure these rights, governments are instituted among men, receiving their just powers under the consent of the governed. So when the people create the Constitution, it's a supreme written will of the people, and it's mandatory, it's absolute. Any man who wants to take office there has to take an oath of office pursuant to Article 6, Clause 3 of the Constitution for the United States of America. That's a citizen. Any member of the legislative, executive, or judicial, both state and federal, who is bound to perform certain duties. See, that's where government, right, mind control. The Constitution is the conscience, the mind. It controls the powers of the governor, of your lieutenant governor. That's what the Constitution is. It's the conscience in writing. This is the way the governor thinks and the powers they have. So when a man gets elected into that improprior persona, in that proper person, that's the person is governor. So they're acting out the role of governor per the conscience of the Constitution of the people as their supreme written will. And so when they violate that, there's a process that's due to them. It's called impeachment. That's done through the legislature. See, the legislature under the House has the sole power of impeachment. And then the Senate has the sole power for trial of all impeachments. And that's how you remove their immunity from being sued and remove them from duty. That's the process that's due to them. And there's a reason behind that, because what was going on in previous history there is the king was dissolving like entire legislative houses. They were, removing certain people and just appointing new governors or new whatever, and putting in his bad guys to rule over the people here. And they got tired of it and said, no. And so they made a process where it's done by the people themselves. So, some people think that, the Constitution is bad, Well, every Constitution after 1871 is all a fraud, including the Idaho one, the complete Idaho one, where this Constitution wasn't made until 1889 and ratified by the people in 1890 of Idaho. So it's a corporate Constitution. It's a fraud. So this leads back into going back over there to the national-assembly.net and reassembling our General Assembly, the sovereign body politic, which is the people. So that's where we're supposed to be peaceably assembling and all that good stuff. And the people are supposed to create the Constitution. So we need to do that by all means. But for all intents and purposes right here, right now, you need to know what your rights are here. So as, say, an employee, okay? What is religion? Religion is about the liberty of conscience, okay? The exercise and enjoyment of religious faith and worship shall forever be guaranteed, and no person, should be no man, shall be denied any civil or political right. Change civil, because this is the Roman civil law, to natural or political right, privilege or capacity on account of his religious opinions. But the liberty of conscience hereby secured. Okay? This is where we have to learn when we're talking about religious exemptions. It's as simple as saying no. Or it's rape. You know, let's apply a fundamental principle here. If, I'll just say it, man and a woman messing around and the man wants to have sex with her and she says no and he continues, is that not rape?
Yep.
Yeah, isn't that rape, Tony?
No consent.
No consent. So, likewise, when a public servant or an employer says, hey, you have to put on a mask, and then you got to tell everybody else coming in here they have to wear a mask, you can't do that because all you have to do is say no. Or that's depriving the liberty of conscience, a common law trespass. You're depriving a fundamental right. This right comes from God. And we don't have to belong to any religion. All we have to do is say no. Because the right is liberty of conscience. One of them, life, liberty, and pursuit of happiness. There's a lot more under liberty than just what we think is liberty of freedom of movement. That's even part of personal liberty. But there's a lot more to liberty. We're free to do whatever the heck we want to do so long as we do not cause harm to another man, giving him standing to claim a right to a cause of action. So when they come at you and say, hey, what are you going to do? Well, I'm going to claim my religious exemption, which is the right of conscience, and I'm going to say no. And you can't fire me because your policy... See, and now this is a hard pill for people to swallow, but corporations, businesses have to have a business license, right? Now, I'm not talking about private membership associations, but if you're going to be in business and you're acting in foreign or interstate commerce, your products come from overseas or from another state, they're shipped to you, and you're selling those products, you have to have a business license because you're acting in foreign or interstate commerce. Okay? Now, Idaho has this nice little section here, Section 11, Article 11, about corporations, public and private. See, we require a business license. Those are those special privileges. That's one of them privileges that was being referred to there. Even in Hale versus Hinkle, there's a reserved right in the legislature to do an investigation to see if they've exceeded the laws of its creation. Well, that's what we're talking about. There's an acceptance of the Constitution by corporations. When we do the business, like Kirk's Law Corner LLC, okay? Kirk's Law Corner LLC is bound by the Idaho Constitution as well as the supreme law of the land, Constitution for the United States of America. And I can't have, any business practices that violate other people's rights. That's a fundamental principle, the rule of law. It's a principle. It's supposed to be self-evident. You can't do that. So, right here, and the police powers, which is policy-making powers, of the state shall never be abridged or so construed as to permit corporations to conduct their business in such manner as to infringe the equal rights of the individuals or the general well-being of the state. Okay? They can't do that. It comes in conflict with the fundamental rights of man to be free. Equal and independent is the key word that's not there in ours. But the law of nations, per the laws of nature, man is to be free and independent of all things created by his fellow man. Is not the Constitution created by man? It most certainly is. So, even this particular thing, anything in the Constitution, either federal or state, that comes in conflict with any of our rights from the laws of nature, natural rights, is void for any effect. Because which one stands on a higher plane, Tony? Natural rights or the Constitution?
Well, the natural rights.
Bingo. Because that to secure these rights, governments are instituted. So if there's been some hanky-panky going on and they've made something that's contrary to the laws of nature, it's void for any effect.
Right. Is your desk as messy as mine?
Actually, it's not too bad. I mean, it's got some messy stuff here, but I got a pretty good size area here. But I got a big desk too.
I'm looking for my Pennsylvania Constitution. I can't find it. But anyways,
oof,
this is good, Kirk.
That's getting bad. That's getting bad. Was there something you want me to pull up there?
No, I was just looking at the Article 11 here for Idaho, and like I said, I got 15 people doing a multiple plaintiff Title 42. They got fired for not getting the vax, working for a county in Pennsylvania. And so, I mean, obviously they have a cause of action, but
yeah,
I was curious if there's a sister sister section that you were just reading out of an Article 11 out of Idaho.
Well, do you want to know how to apply the Idaho Constitution in Pennsylvania?
Well, it's, I guess it's full faith and credit.
That's absolutely right. What does it say? Article 3, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Is not the Constitution a public act?
That's Article 4?
That's Article 4, Section 1. Full faith and credit clause.
Yeah.
See, it's a supreme written will of the people. And when we're talking about fundamental principles, 2 plus 2, it applies equally everywhere within the Union.
So what people should do is take, constitutional carry in Idaho and go over to, Chicago and say, hey.
Well,
right?
That's what the Rahimi case actually just did. The Rahimi case just struck down any legislation that says you have to seek permission to carry a firearm.
So was that the New York one?
Yep. Pardon me, that was the Bruin case.
Bruin. I was going to say you threw me off.
Bruin. June 12th of 2022, and then the Rahimi case is the one that abolished the United States Code regarding the domestic violence protection orders. You lose your right to keep and bear arms once you get issued a domestic violence protection order. So that's been declared unconstitutional and abolished. And again, folks, pay attention to what's going on here. It all started with the Roe versus Wade, right? Should have been a major wake-up call, this change that's coming. They're going back to real law, the common law, not the Roman civil law, not under the monarchy where the judicial branch has the power to make law and all that stare decisis that's common law, how they do that under a monarchy. No, here in America, the judicial branch doesn't have the power to make law. And when we say case law here in America, it's the law of the case, and only to quote, what's her name? Who's the gal there? I'm drawing a blank. What's that gal's name that the constitutional gal?
Tony Barrett?
No, I went down there with you, and we went to Yuba City, and we saw her, and then we went over
Oh,
to
Chris Ann Hall.
Chris Ann Hall. Thank you. And she says, it's the law of the case and only applies to the parties to the case. It's a contract. It's a resolution. See, that's the difference between our republic and a monarchy. Back to that Black's Law Dictionary, 4th edition, law is that which is laid down, ordained, or established. Declarations, declare, down, clarify in writing. Declarations lay down the law, which is why this is what? A Bill of Rights or a Declaration of Rights? This is laying down the law. Declaration of law. Rights as law. I mean, it comes from the French word droit. They're synonymous. Right and law is the same thing. This is law. They want us to believe that the statutes, the code is the law. But it's not. So, again, knowledge is power, folks. And wielding that double-edged sword by speaking it. And then, what do we got to do? We got to put it in writing sometimes. Because they're like, oh, well, you got to have a religious exemption form. No, I don't. Okay, back to the principle here, the man and the woman there, and she says, no, well, I got to have a form to exempt you from rape. Or exempt you from having sex. I need it in writing. I need that exemption form. You know how ridiculous that sounds now? It should be as simple as, no. And you can't tell me to put on a mask. Come on. What I cannot do in my person, I can't do through the agency of another. So fundamentally and principally, if I can't do it, if you can't tell your neighbor to do it, then nobody else can tell you to do it. If you can't walk over to your neighbor's house, knock on his door and say, hey, put a mask on. If you can't do that, fundamentally and principally, nobody else can do that to you. Just logic and reason here. So, that's what the liberty of conscience, right? The internal dictates of the mind. We have that right to say no. And they cannot have a policy that infringes. Is that not an infringement? Okay? It is an infringement. If you can't say no, that's infringing on the right to say no. If you can't say, no, I don't want to have sex with you, and then if he continues, it's constituted as rape, then what is it when you say no to your employer or to a public servant, police officer, sheriff deputy, any kind of so-called law enforcement officers? When you tell them no, remember, they're the servants. They're bound by this. This is the other maxim of law, aside from ignorance of the law is no excuse. To know a thing and to be bound to know it are regarded in law as equivalent. That's Article 6, Clause 3. They're bound to know this. They're already bound to it. They've taken an oath, subscribed, sworn, signed, sworn, and subscribed. Okay? That's required. So we don't even have to ask them for their oath of office. We can just assume that they have one and treat them like they do. Now, later down the road, if you get into a court case and you find out they don't have one, it still would be irrelevant, wouldn't it? Because they were clothed with the authority. They put on that disguise, they received the emoluments of the office, and they took this action. It's about the actions that they take. Now, I get that some people want to go after their oaths and their bonds and all that stuff, but that's a whole different rabbit hole and all that good, funky, happy stuff. Okay? It's all part of that corporation garbage. We need to stick to the process that's due from either the common law, or if it's dealing with the public servant, you got to follow the Constitution, because again, that's law of the land, due process of law. That's the law, not the statutes, not the code. The process comes from the Constitution. And I'll show you that right here from our rights, where it says that. When we talk about the right of political power, all political power is inherent in the people. Government is instituted for their equal protection and benefit, and they have the right to alter, reform, or abolish the same whenever they may deem it necessary. And then this is it. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. Take you right to Hale versus Hinkle, where it says exactly, almost exactly the same thing. It says special privileges or franchises. That's a business license. Why do you think we require a business license for those acting in foreign or interstate commerce and have their doors open for business? It must be like how I defeated both of my cases. It must be a lawful, not legal, lawful condition upon entrance. Okay? It has to be a lawful. This is why the business license binds them to the Constitution. And everybody, self-evident about our right of conscience, everybody's supposed to know that we can't dictate to another man. It cannot be part of their business practices. It can't be part of their policy. Because policy doesn't stand on a higher plane than our rights. Now, this is the one that we most commonly quote, is that there's a clear distinction between a corporation and an individual, right? And that the clear distinction between an individual and a corporation. The latter has no right to refuse to submit its books and papers for examination as suit of the state. Corporation. The individual may stand upon his constitutional rights as a citizen. Now, we can look at that as a lowercase c as being the free inhabitants, the inhabitants, or the people. That's a different kind of citizen. Go read the Law of Nations, Book 1, Chapter 19, subsection 212, for citizen, capital C, is a member of a civil society who is bound to perform certain duties and is subject to its authority. Where the free inhabitant is a different kind of citizen, where you've established your residence, you own land. You've declared that you are settled here. Okay? That's what gives you political rights, because otherwise you don't have political rights, and that's okay. You can stay over there as a free inhabitant, as man in the private. Leave me the frick alone. Government has nothing to do with you. Beyond what? Look at what Hale versus Hinkle says. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to criminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the what? Law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. That's an and, because due process of law is the law of the land, common law of the land. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a what? Warrant of the law, which must be obtained through due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. A common law trespass. So that is what they're doing. It is a common law trespass. Okay? Now, upon the other hand, a corporation is a creature of the state, is presumed to be incorporated for the benefit of the public. Huh. What does that say? Acceptance of Constitution by corporations. No corporation or municipal corporation in existence at the time of the adoption of this Constitution shall have the benefit of any future legislation without first filing in the office of the Secretary of State in acceptance of the provisions of this Constitution in binding form. That's incorporating. Your business license incorporates you into the body politic, which makes you one of the people. This is how you become one of the people. Because the people pay the bills. They pay the governor's wages. That's how you get political rights. Again, see Law of Nations, Book 1, Chapter 19, Section 212 and 213. That's how you become one of the people. Right here. Otherwise, you're a free inhabitant. And it's okay to stay there. It's okay not to have political rights. Because it wouldn't apply to you anyways, because you're not bound by it. So, back to Hale versus Hinkle, because this is where it comes in. Right here. It receives certain what? Special privileges and franchises, and holds them subject to the laws of the state, the statutes, Constitution, the limitations of its charter. How about those articles of incorporation? You're muted, brother. Articles of incorporation.
Did you use this in Dragonfly? This one?
Oh, yeah. Its powers are limited by law. It can make no contract not authorized by its charters. Its right to act as a corporation only preserved to it so long as it what? Obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. Now, can we understand the right and no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature? This is the reserved right that Hale versus Hinkle is referring to. Now, how do you get to the legislature? That's that political lawsuit, the right of petition. Right of assembly. The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. Now let's read it backwards. First, you petition the legislature for the redress of grievances, which calls them in to peaceably assemble so that we can consult for our common good, and the prayer for relief instructs our representatives on what to do. That's where we make our demands under a prayer for relief. Just like in motion practice. You have a prayer for relief under every motion, and you make your demands that you're entitled to that relief. So, now what happened? What you're actually doing here is like, okay, well, if they are acceptance of the Constitution by corporations with their business license, and the legislature, policy making power of the state, never be abridged or so construed as to permit corporations to conduct their business. That's the laws of its creation. Are they exceeding the laws of its creation? Whether it's exceeded its powers. It can't supersede our rights or the statutes creating that. See, this is when we talk about, restaurants or outlet stores or anything like that, right? And this is where we get into that trespassing. Oh, well, you're trespassing because, well, we have the right to refuse service for any reason. What's the reason? Because you're not putting a mask on. That's not a lawful condition upon entrance. Your policy, you've exceeded the laws of your creation, and you've exceeded my right. And you can't exceed my right. You're bound to know that. fundamentally and principally, that's self-evident. That's the common sense law. That's the ignorance of the law. Right, says the law. Then, to know a thing and to be bound to know it or regard it in law as equivalent is the business license that binds them to the Constitution. It's like Article 11. They're already supposed to know that. But now it's a double whammy because they have a business license, and now we get to revoke their business license because now they have policies that are in conflict with our rights. And we should not allow that in our communities. Now, I know there's some people out there that will argue with me on this, but that's a fact. Because fundamentally and principally, if no man can deprive a fundamental God-given right, then how can a man under the guise of doing business deprive a God-given fundamental right? That is completely illogical. Because I can definitely sue a man suits between man and man, suits at common law, for deprivation of a right, infringement of a right. It's called a common law trespass. So therefore, I can sue a man acting under the guise of a business, but you have to go after the business because the business is making the policy, but it's still just a man. And then there's that immunity. It removes the immunity. Now you can sue, you break him down to a man because he's acting in his individual capacity and not his official capacity, in the sense of if it's a public servant, that's official capacity. Now, I just recently kind of discovered that, but nonetheless, there's a principle that's applied there. We wouldn't call it official capacity if it's a private business, or I should say private public business open to the public. It's not funded by public funds. So this is where we have to understand the difference between private public, and public.
Very good.
Right? So public is created by the legislature, and it's funded by the legislature. Private public, it's created by a man with a business license that's incorporated into the state, but has an open sign that's open for business, and that's the invitation to come in. They're opening their doors. Come on in. Buy my stuff. Okay? Now, private, there's no open sign, and your products are made by you. They're not imported. Okay? That's the key, because that's Article 1, Section 8, Clause 3. The second you order products and it comes to you and you're selling those products, you have to have a business license because you're acting in foreign or interstate commerce. We want to make sure that what you're selling there is good to go, and we can track it down back to where you even got it from if it has to go that far. Some people disagree with that, but I do not. That's the way I think it should be. But if you really want to be private, you want to grow potatoes. And then you say, hey, I got some potatoes for sale. You can do that. Just don't put up an open sign. You don't need to have an open sign. That should be by word of mouth within your community. All right? So now that we've kind of got the basics here of the fundamental principles of the law and due process of law, this is part of the remedy. Okay? Right? This is the process that's due to businesses. Right? Because there's a reserved right in the legislature to investigate. See, the legislature does the investigations. A lot of people think that it's the executive branch that does investigations, and it is not. It's the legislative branch. Okay? So, as it is written, we got to go to the legislature. Because, like finishing Hale versus Henkel part here, it would be a strange anomaly to hold that a state having chartered a corporation to make use of certain franchises could not, in the exercise of its sovereignty, the sovereign body politic, inquire how these franchises had been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose. Which would be to revoke their business license. Okay. So again, back to the right. Petition the legislature for the redress of grievances. That's a petition. Okay. So, anything you'd like to add on to this, Tony?
Nope, you're laying it down straight from the foundation. I mean, there isn't too much wiggle room that I see.
Those are all facts of law, the letter of the law, with your case law behind it, your stare decisis of the opinion that cites facts of law. It took you right to the facts of law, and all they're doing is citing what the facts of law, our rights, dictate.
Yeah, well, these confidence men want to sit there and discuss legal theory and circular arguments. Ridiculous.
Right. Yeah. Well, they hijacked our form of government, and everybody's been brainwashed and indoctrinated to believe that, well, when we got a problem, we go to the judicial branch, right? Yeah. You better hire an attorney. No, be your own attorney. Wisconsin Constitution, Article 1, Section 21, rights of suitors. We all have the right to prosecute our own claims. Uh-oh. Yeah. There's no distinction between criminal and civil on that, folks. So criminal complaint A091 form is one way to file a criminal complaint with the Federal District Deputy Attorney General, executive branch, not judicial. Okay? And if they don't, you still have the right to prosecute your own criminal complaint. Go ahead, Tony.
Does that go to the United States Attorney, the 091?
The A091 is a federal district deputy prosecuting attorney. That's down at your federal building, where most people think that's just a courthouse. It's not just a courthouse. There's all sorts of executive branch officers in there. You've got the FBI in there, the CIA in there, you got U.S. Marshals in there, you've got your Deputy Prosecuting Attorney General in there. All in that same building. Now, again, to equip you folks, that's why I mentioned and brought up Wisconsin Constitution, Article 1, Declaration of Rights, Section 21, Rights of Suitors. We all have the right to prosecute our own claims. Okay? Because it has been met with, well, you can't do that. It's for law enforcement. No, go read it. It says prosecution forms or something like that. You know, when it talks the categories as a kind of a general definition, law enforcement, blah, 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 blah. It's not just for law enforcement. But they've been brainwashed and indoctrinated too, sitting behind the chair there. Call them gatekeepers.
Yeah,
and here's the key, the golden key. You have to know your rights.
Yeah, if you're going to your clerk for information, they're going to talk you out of every. Clerks are the bane of the existence of law from way back into the Roman times. The clerks are the worst people to even ask anything for. Mm-hmm. And you don't ask them for stuff. You tell them that they're giving you access to the court. They cannot deny you access for a fee. They cannot tell you. I had a clerk one time, Kirk, I was fighting a ticket, and they're like, oh, they're not having motions hearing today. And I'm looking at my thing, and I says, well, it says I'm here today. Well, that judge isn't here today. And a bailiff overheard this clerk telling me to leave, that they weren't having my hearing, but I wasn't going to do it. And he goes, oh, no, we're having a special hearing for Mr. Pellegrino today. So if I'd have listened to that clerk, I would have forfeited, my right. And I actually won that case. But anyways.
Awesome.
Clerks are the worst. They're just the worst.
They're gatekeepers, right? And this is where you have to have the golden key. So the golden key for this which is some people that I helped out of California. I already gave them the keys to this, right? And that's what they ran into when they went down there. They're like, no, we have the right to prosecute our own claims. You can't deprive us of the right to file a criminal complaint. Can he file a Title 42, 1983 civil complaint? Well, yeah. Okay, well then here's a criminal complaint. Just because it's criminal in nature doesn't change the fact that I have the right to file a complaint.
But a restraining order is a criminal complaint. It's short form.
Right. Well, the thing is, you know, once you know your rights and you cite your right, and you say, no, I have the right to prosecute my own complaint, my own claims, right? Whether it's criminal in nature or civil in nature is irrelevant. And technically speaking, we should be able to walk right into to the magistrate, lay the complaint before the judge, jump on the stand, the accuser, be sworn in, testify. Then it's supposed to be reduced to writing and subscribed and signed by the whoever administered the oath. And then that's your deposition right there. Bam. On paper, document, on the record, in the record. Paperwork and verbal. And that's the judge has to do a determination right there on the spot. And then that's where you have your, I think it's, what was it, AO 442 for the warrant for arrest. You could have those all prepped and ready there too and submit to the judge once he makes a commitment on the complaint. But we're not quite there yet.
Can we fill out the warrant for arrest for the acting judge too? The way some of these judges are, they commit felonies right during proceedings.
Right, but the problem with that is they have that immunity from that process. The process that's due to them is impeachment.
Okay. Unless it's deliberate indifference.
No, nope. That's that immunity. They have immunity from being directly sued. You have to go due process. See, this again goes back to the reasons why our founders put this process in there, because of what the king was doing, what the prince was doing.
Getting back to if I give someone a right to do something, I have the same thing. If you see somebody committing a felony, if an officer sees someone committing a felony, he could arrest them. And so if we see the judge committing a felony, we should be able to do an arrest. I'm not saying we would be successful, but we should have that right. And qualified immunities are kind of like it's an application. It's like you have to meet the qualifications to get a loan. And if they're committing felonies in open court, I mean, the sergeant at arms, or you should instruct the bailiff, the judge has committed a felony and exercised deliberate indifference. I'm not telling people to do this. Do not do this, okay?
Yeah.
I'm just saying.
We're just, this is in theory, folks, theory.
Well, I think it's the law, but everything's theories of law according to them. So, anyway.
Well, technically speaking, the sheriff's supposed to be the bailiff. And the sheriff comes from essentially the common law under the executive, per se, executive power, executive branch. And he's supposed to be the go-between between whoever's prosecuting, whether it's a city prosecutor, county prosecutor, state attorney general, or even one of us, right? Because we all have the right to prosecute, because we can't delegate a power we do not possess ourselves first. And make sure that we're not asking that judge to do anything that outside of our scope and authority to do. And then likewise, ensuring that the judge doesn't exceed his authority, because whatever the judge says for his orders goes to who? The bailiff, the sheriff, to execute it. And this is part of the checks and balances, is the sheriff's supposed to go, well, hey, judge, you actually don't have that power, and I will not execute this order. It's an unlawful order. Right. The maxim of law is a judge who exceeds his authority is not to be obeyed. It's a maxim of law. That's a rule of law, a principle. So right there, that would nip that in the butt. You wouldn't even have to place the judge under arrest, because the executive branch, the sheriff, as the bailiff, is doing his duties he's supposed to be performing under the emoluments of his office that he's getting paid to do, right? Ensuring justice. Making sure that that judge doesn't exceed his authorities. So, In essence, that's how that's supposed to work lawfully. But I have talked to some sheriff deputies and some bailiffs and stuff, and they're like, oh, well, I can't do that. I'm like, I have to follow what the judge says. And I'm like, no, you're the executive branch. He's the judicial. You're actually there to provide oversight. You can tell the judge no. Maxim of law. Judge who exceeds his authority is not to be obeyed. You're actually supposed to know whether or not the judge is exceeding his authority or not. Because you're bound to know it. Got an oath of office, right? Oh, yeah. You're bound by the Constitution. You're already deemed to know this. Oh, wow. That was actually a conversation I had in an elevator there at Ada County Courthouse with one of the bailiffs. He was actually kind of agreeing with me on some of the stuff that I was talking about. And, we just ended up in the elevator, the same going down, and we had this short little conversation. So it was quite interesting that he actually kind of saw things my way, actually. He wasn't so sure about stopping the judge from doing certain things, but I planted a seed, I'll tell you that.
Yeah. It's funny when they're not, when they're not forced to perform, they kind of agree, but when they're, it's just like, these guys are getting paid. And anyway, I don't want to get into that. I'm going to back off. I'm not going to be negative. Keep teaching, bro. I don't want to go sideways on you. Let's keep moving forward.
Yeah, I know. It's real easy for both of us to get sidetracked here. So it's going to kind of go off into a little bit on your side of things with, Title 42, 1983 for state or federal actors, which is what Title 42, 1983 is for, which I've recently discovered on the EEOC stuff. I'm helping a gal right now who's suing under the EEOC, and of course they said, oh, well, we couldn't really find anything, but you have a right to prosecute. And so she's prosecuting, although it's civil per se, and because it's a private corporation. Under this stuff right here. So would like to get people prepared for this so we can start nipping this in the butt right from the get-go. Right out of the gate. Let's just shut this down right now. Over to you, brother. What do you got? What are you thinking?
Yeah, I think that we definitely should do a 1983, probably a 6-week course. I think if you were able to do 3 hours a week, it might be probably at least a 10-hour course. I don't know. I mean, if they want to learn the procedures, and so there's no surprises and kind of the stuff that you need to know as far as procedure and what to expect. Because just because you know the law, it doesn't mean that they're going to follow the law. And so preparation is key. And if you're using the wrong procedures in practice with pleadings and your motions, the judge isn't obligated to give you legal advice or lawful advice on how to do your paperwork properly. So it needs to be definitely tight. And most most sui judices, I've seen a lot of leniency given to a lot of people under 1983, and I have not yet to see in federal court where people ask for more time and have not gotten it. Like, you'd really have to stretch it to get like extensions of time and be denied on that. They just throw they want the cases to last longer because there's a QSIP number and a bond on the case. They're like, yeah, let's delay it 45 days. I mean, it's amazing how slow these things move.
Yeah. And it's all about excusable neglect, right?
Yes, that's exactly what it is. When you screw up and you neglect, your duty to, administrate properly your paperwork, then yeah, they call it excusable neglect.
Yeah. So, should we oh man, I messed up the screen here. Go over this lawful notification letter that I had previously done and used. So this stuff is coming around again, so it's the same, pretty much the same stuff. And this is just the short one. This isn't the long one. This isn't the 62 pager. This is just the 4-pager. So this one is the short and sweet, right? Lawful notification letter, notice of liability. Hey, you're going to cease and desist this crap, or I'm going to sue the crap out of you. So this is the precursor. Due process of law here. What's the first fundamental principle of due process of law, Tony? Notice.
I'm sorry, I was reading something. What was the question? I was looking at something. I was reading the chat. There's a lot of chat going on.
I hate when I do that. Okay, so what's the first fundamental principle of due process of law? The number one thing.
Number one principle of due process of law is due process.
No, but what is remember
the process that is due.
Remember that rule of procedure you were telling me about, like 4.1 or something like that? Yeah. What is that?
Okay, as far as in this case, it's fair notice, I guess.
Yeah. That is the first step of due process of law. Notice an opportunity to respond.
Yeah.
Okay? And setting up for a lawsuit, you have to prove, technically speaking, if they know anything about the law and due process of law, you could demand, well, did you give me notice? And afford me the opportunity to correct the errors of my ways? Because, I am a man, so I make mistakes. I don't know everything. No man shall know it all. And, hey, I could be induced under fraud or fear, false evidence appearing real. I might be acting out of fear. But then when you put me on notice, you afford me the opportunity to read this and go, well, wait a minute. What? Let me go check this stuff out because, So, notice to agents, notice to principal, notice to principals, notice to agents. So it doesn't matter who you hand it to. This notice to give you the opportunity to correct the errors that your corporate policy is in direct violation of our rights. People of Idaho have been unlawfully deprived of their rights without due process of law under color of authority and color of law. That color of authority is the Hobbs Act, clothed with authority. Them disguises they're wearing, including your employer. Okay? Color of law. Well, what's color of law?
It's not the law. It's them acting under the code.
That's right.
Acting under policy. Acting under ordinance.
That's right. Any statute, rule of procedure, regulation, city ordinance, those are all color of law. I know a lot of people don't understand that, but you need to. It's policy. It is not law. Okay. So this is where you're giving them notice and you're affording them the opportunity, right, to correct the errors. Hey, they're just in an error. And this is proper diction. Jurisdiction. Because it's just an error. Right? Thinking error. Be advised. Okay, you're placing them under arrest. Because that's what be advised means. Okay? What do we got here? Alright.
By the way, that's Rule 5 of Federal Rules of Civil Procedure, is the fair notice.
Yeah, I remember it was right. Rule 5 of Federal Rules of Civil Procedure is you have to give them fair notice. I knew it was like right there, 4.1 or something, because that's actually special appearance. But that's how your appearance there. But I knew it was right there. Okay, so be advised. Placing them under arrest. You're tying them up here. You are to cease and desist any further action and any action taken by any agent or any other part of your agency will be deemed as a trespass of the law, capital L, after notice. You will be subject to a tort, this is common law, of $250,000 United States dollars per agent per violation and $500,000 United States dollars per agency per violation, and a petition pursuant to Article 1, Section 2 and 10 of the Declaration of Rights of the Constitution of the State of Idaho, and a criminal complaint. So, think about that. everything that I just covered. Article 1, Section 2, no special privileges or immunity shall ever be granted that cannot be altered, revoked, or repealed by the legislature. Article 1, Section 10 is the right to petition the legislature for the redress of grievances. That's how we effectuate that. Okay? Your corporation is here put on notice to cease and desist all trespass of the law. And again, I'm using the capital L, common law. Rights as law. Or we will pursue lawful actions against the individuals in their official capacity and or the corporate entity's business license and or bonds.
Would you just look at it?
Would you look at that? Now, this is still set up for their orders of quarantine, right? All district health, the stay-at-home, stay-healthy orders, the lockdowns, all that stuff, that's what this is in reference to. So all district health departments' orders are unlawful and wholly void for any effect. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 137. That's right. Miranda versus Arizona, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Okay. Then you got Norton versus Shelby County here. An unconstitutional act is not law. It confers no rights, affords no protection. It creates no office. It is in legal contemplation that, as inoperative as though it had never been passed. Because it's void for any effect. It's a nullity. Nullifies it the second it comes out. It's just done. Okay? And this is U.S. versus Miller, or Miller versus U.S. on appeal. Execution of process and the performance of duty by constituted officers must not be thwarted. But these agents, servants of a government and a society whose existence and strength comes from the these constitutional safeguards, are serving law when they respect, not override, these guarantees. The liberty of conscience hereby secured. The right of religion is guaranteed. The claim and exercise of a constitutional right cannot thus be converted into a crime. And just so we're aware, this is the actual verbiage, because I went and did my own research on all of these cases. And so many people just say Miller versus the claim and exercise of a right cannot be converted into a crime. Yes, I get that. But the full quotation of the opinion, execution of process, and the performance of duty. Remember, rights impose a duty. Where there's a right, another man owes him a duty.
So this is a private business we're talking about, correct? This lawful notification letter? Because if we do it to a, like I says, like my people in Pennsylvania, they worked for a county. And so the executive, the CEO, the chief executive officer over the county, decides he's going to create his own law without the legislative body doing that. Void ab initio. He has no power to do that from the beginning. Yeah. And so in a sense, it's a improper guidance document because he's using mandatory language.
But see, here again, separation of powers. Since when does the executive branch has the power to make law or make a statute?
That's why this case is killer that we got going on.
Well, see, this is where you could go in for a constitutionality challenge.
Where
does the executive branch get to make its own law?
Yeah, I don't know at what point I want to do this, but yeah, that's definitely on the table. Like I says, I'm consulting. It's funny how people get a little bit of knowledge.
Yeah. See, this would be perfect for any governmental agency.
Oh yeah.
As well as a privately owned corporation. Because watch when I get down into here who it applies to, right? Declaration of Rights, which I just kind of went over those. Okay, and that's why it's right in here, the guarantee of religious liberty. But the liberty of conscience hereby secured, nor to permit any person, that's McDonald's or the sheriff or your county commissioners or whoever, right? Organization, hello, or association, to directly or indirectly aid and abet, counsel, or advise any person to commit the crime of bigamy or any other crime. That's right. So, oh, well, you guys have to implement this mask mandate. It's not a mandate, first of all, and you have no authority. That's aiding and abetting in the crime. Okay? And then, let's see, what's Section 13? This is Idaho stuff, just so you're all aware. Nor be deprived of life, liberty, or property without due process of law. We went right over that with Hale versus Henkel. It's a due process clause from the law of the land. Okay? And there's our Article 11, corporations, public and private. Okay? So here's the notice of liability. 18 U.S. Code 241, conspiracy against rights. Now, 247 is where it gets in damage to religious property, obstruction of persons in the free exercise of religious beliefs. That's a felony. Under 18 U.S. Code 247. That's $250,000 a pop per man and $500,000 a pop for your corporation in punitive damages under a criminal complaint. This is not civil, this is criminal. This is tort. Okay? And actually, technically speaking, tort wouldn't be punitive. That's going to be under a criminal complaint A091. But, of course, a good old 643 there, you know, the emoluments one. Or emolument. So, most people are aware of 241 and 242, but it's 242 is the main one, deprivation of rights under color of law. Okay? The 247 is about religion, so if they deny you your right to say no, they just committed a felony. If they have a business license and they're incorporated, they're bound by the Constitution, bound by the supreme law of the land as well. This applies. If it's a public servant, oh yeah, they're definitely bound by this. Okay? See, that's the whoever being an officer, employee, or agent of the United States or any department or agency thereof having received public money, which he is not authorized to retain as salary, pay, or emolument, fails to render his accounts for the same as provided in this law is guilty of embezzlement. That's right. That's 643. Now,
I wonder if that would apply to. You think that would apply to stocks, public money?
To what?
In corporate law, do you think using of public money? Do you think that you could apply that somehow to stocks?
Stocks
in a corporate sense? Yeah, because it's traded on the public.
I mean, are they? Well,
I'm helping somebody on a case right now. That's why I'm just trying to use every angle.
Yeah, that'd be a tough one if they're actually using public money from the Department of Treasury.
Okay. All right. Yeah, it just popped into my head.
Yeah. And then, of course, we have 18 U.S. Code 3571, which is where we get the sentence of fines of where it's $250,000 for a felony. Okay? And then it's the 500. It's let's see, for misdemeanor, it's only a Class A misdemeanor that does not result in death is $100,000. The Class B or C misdemeanor is not more than $5,000, or for an infraction not more than $5,000. So, but I like to hit him with that $250,000.
Well, to go down further, it's $500,000 on the.
Yeah, for organizations.
Yeah, there you go.
Yeah, for the corporation. You know, your organized crime. No, I mean organizations, right? So this is where you get for the felony is $500,000. So when that organization, your corporation, your boss starts instituting this policy and tells you, no, you gotta put on a mask, you gotta get the vaccine, that's $500,000 a pop for the organization per felony. Okay? And the same goes for that same organization business that wants to try to tell you you have to wear a mask. Okay, to come in. That's not a lawful condition upon entrance. And then it's does not result in this 200,000 for the corporation, for the organization, right? And that's it. I mean, that's the short and sweet of it right there, folks. That's your lawful notification letter that you're going to tell, that you're telling them this is the liability part, right? And that's what goes on your criminal complaint. And then you've informed them that you're going to go to the legislature. Where was that? That was right there in the beginning. Right here. Right there. And a criminal complaint. So the petition to the legislature revokes their business license. And the criminal complaint does the punitive damages. And then depending on if it's a state actor or federal actor, then you can do Title 42, 1983, or if it's not, then you can straight sue them. You can sue them through the state, or you can do federal. But if you're going to do federal, better make sure that they receive federal funds in some way, shape, or form. Especially like in the medical field, you know, they're actively engaged in billing for Medicaid or Medicare, getting some sort of federal funds under Title IV. Bam, then you can do federal. But
well, most of these private organizations, they took COVID relief funds, they took federal funds, and when you take
absolutely, they got some sort of funds going on.
It's called a federal grant, and within the federal grant, there are conditions that you cannot exercise. If you take the federal grant money, it's in the grant money under internal controls that you cannot show prejudice or violate constitutional rights by taking the grant. And if you do, you can be investigated by OIG, Office of Inspector General, and you would have to, found guilty of it, you would have to repay every nickel. Mm-hmm. That's another, shit sandwich that you can throw in there.
Yeah. So a comment over here on Telegram, I really haven't been paying attention to them, been reading, talking about how the counsel for Missouri legislature told me through my rep. So there's your first problem. Some bar member over there saying, oh, you don't have that right. You don't have the right to instruct your representatives. The hell I don't. It's a right. Now, this is what's called the Savings Clause, either Article the 9th of the Bill of Rights. Some people refer to it as the 9th Amendment, but these are supposed to be articles in addition to. The Constitution, again, we're talking about Declaration of Rights. So every state constitution with a Declaration of Rights has this reservation of rights, the same thing as the 9th. This enumeration of rights shall not be construed to impair or deny other rights retained by the people. Then you can also go to the 10th Amendment on that one. These are powers retained by the people. But see, they prey on our ignorance. We don't know. So, the first thing I'm going to recommend is y'all frickin' read the Declaration of Independence. You read your state constitution and you read the federal constitution. You gotta have this knowledge, folks. You gotta read. You have to understand the fundamental stuff. The fundamental law. The rule of law.
The legislator's trying to instruct your guy from his question, and I guarantee he had probably read the state constitution or the federal constitution.
No, because they all go off of the code, right? This is all bar code.
Well, they swore an oath to both constitutions, so they're bound by it. The legislators, they're bound.
Right. But again, they haven't read it either. They don't know. Everybody's been taught, well, you better go talk to an attorney about that. And the attorneys, as a bar member, is who they're actually referring to. They're not actually attorneys. They're members of a club, an association. Okay? So, an attorney is one who prosecutes. Prosecuting attorney prosecutes his own claims. That's why it's called a durable power of an attorney. In fact, has nothing to do with being a member of the bar. That's a bullshit lie that's out there for a long time now. But again, this is where knowledge is power, and our tongues are sharper than a double-edged sword. Well, wait a minute. This enumeration of rights shall not be construed to impair or deny other rights retained by the people. Well, it's enumerated over here in the Idaho one. It's enumerated over here in Texas. It's enumerated over here in Tennessee and Wisconsin and Florida, and the right to petition, remonstrate, and address. Remember, this is just merely declaratory of the common law. That's why it's good to read around some other constitutions and other bills of rights. And then, of course, reading Lex Parliamentary Americana, the law and practice of the legislative assemblies of the United States of America. It's the law. You're not going to find that parliamentary practice, common law, over here under the Constitution or the statutes. You got to go to the body of law regarding parliamentary practice. The political power comes from the common law, the lex non scripta, essentially the unwritten law, but it is in writing. So hopefully that clears up for you over there, Jay Sharon, over here on Telegram. Deanna Patriot. Yep, absolutely. Even if it's a private, even without a business license, a private business cannot infringe on a man's rights. Absolutely. Those are supposed to be self-evident. Ignorance of that law is no excuse. So, Jay Sharon and everybody else out there that has the same going, what? Go over here to my website, kirkslawcorner.com. Go into the library tab up here on the right. Here says library tab. Library. Okay. And here's that elements of the law and practice of the legislative assemblies in the United States of America by Luther Stearns Cushion. Okay, this one here is published in 1856. This is the law and practice. When people say, well, where can I find this common law? Where can I find the common law? Right here. Here's the common law and practice for parliamentary practice in the United States of America. This is the 2010 edition of Mason's Manual Legislative Procedure. Okay. 70% of the states use Mason's Manual Legislative Procedure. And when you go in here, almost on every single page of this book, it references cushion. Cushions, see cushions, because they're pulling from the law. So, why not just skip Masons and go directly to the law? I mean, that seems pretty logical to me, doesn't it? How about you?
Yeah, this is from the library of what? University of Michigan? Oh, that was just a stamp.
No, this is my website.
No, I was looking at the stamp on the document you had.
Oh, yeah.
Yeah, I thought it said something else. My bad. That's not important. That's just a stamp.
Yeah. And then here's the Jefferson's Manual, right? And then here's the 1953 edition of Mason's Manual Legislative Procedure. I do have the 2020 edition, but I don't really like it because they've taken out a lot of stuff.
Pretty much most of the explanations, if you don't know, be able to read between the lines, you're going to miss a lot of stuff.
Yeah.
2020.
So this is the reason why I say just go to the real law and practice. Grab this 2010 edition right here and thumb through it. But everywhere it says cushions, go over here and read it. And this is, still waiting for everybody out there on Telegram, that KLC American Patriots that I put together. That was the last thing I posted over there, and there's only been one man that opened up this elements of the law and practice of the legislative assemblies and read something out of it and made some comments about it. So if you folks don't want to, put in some work and learn and read and share and break this up so that all of us can learn at the same time, this is called breaking up the load. There's a lot to read there. And I just want to see how many people are on board with reading, learning, and doing this and sharing what they've learned. Again, splitting the load up. If we had 50 people dive into the elements of the law and practice of the legislative assemblies here, we could cover that whole book in like a month. Find the good parts. Break it down into, like I said, go into the table of contents. Pick one little chapter out of this thing and read it and share it. But I can't seem to get anybody to do that. So, Brother Oscar, thank you. Yeah, when I put out the word there for Oscar, thanks for the picture there for us, flyer. But again, remedial reading here. The treatise on arrest and false imprisonment, the authority of law. Here's the law of nations, and here's the report of the Commission on Unalienable Rights. That's why these ones are first. You really should start here reading this. But if you're going to go into the legislature and that kind of stuff, that's this one. This one's the law and practice of legislative assemblies in the United States of America. This is where you read from here and you cite from here, and where you kick them bar members, they're sitting over there in the corner, you kick them in the balls with real law. Okay? That's that wielding that double-edged sword when you speak it. It says in there the same thing as Mason's. So you could quote both of them. But Mason's only quotes the same from Cushion's here. That the right of petitioners to present their own petitions. Now, Miranda versus Arizona. There shall be no rulemaking or legislation that would abrogate the right. Which one stands on a higher plane here? Does the right stand on a higher plane than their rule of procedure for the legislature? I think so. Being the rules of procedure for the House or the Senate's made by them. And there's supposed to be rules of procedure for the proceedings. Look at what Mason's Manual says. Mason's Manual of Legislative Procedure. Because it's rules of procedure. It's not law. It's procedure. Okay? And the Constitution says that the House and the Senate have the power to make their own rules for their proceedings. It's rules of procedure. But they have to stay in the confines of the law and practice. Okay? So, again, reading means reading, folks. Gotta read, gotta read, gotta read. Oh, let's see. Where did I get my little petition here? Oh, man, I got so much stuff. Wait. No. Where did I put them suckers?
So here it is, Section 72. Legislative procedure is not within the control of the judiciary. It is it is for the judiciary to decide whether there has been compliance with constitutional provisions and whether a bill of the legislature has become law. Okay, and that's the whole thing where they want to start making their own rules in the executive branch. Sorry, it's not your function.
Separation of powers. This is. You remember this, right? When we went down to the GOP summer meeting down there, and our Attorney General, he had his back to us. We didn't know who he was, right? Remember,
Yeah,
he was like, "Hey, I know, no, but this is the power that properly belongs to the legislative branch, and the legislature just needs to buck up and make it, and the executive branch can just deal with it."
I get a picture of you pointing your finger at him when you're talking. Brad Little, you're like
No,
you're
no,
like
no, 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 no. Oh yeah, that was it. That was at that same. No.
Yeah, that was at that we didn't know who he was. He was brand new at the time.
No. I'm talking about the Attorney General when we were up in the rooms at the GOP summer meeting. That was the GOP dinner thing.
That was the dinner thing. Yeah. Okay.
Yeah. When we were sat in on the meetings in there regarding the legislature and all that stuff, and the Attorney General was sitting there, he had his back to us. We didn't know who he was.
I don't know if I was in that one or not.
Yeah, you and I sat next to each other, and I went outside to go smoke a cigarette, and he come walking out, and you're like waving me over.
Oh, that was Wadston, wasn't it?
Yeah, and I come over there, and I'm like, okay. Come up there, and he had just walked out of the doors there with his wife, right? Headed to the car, and I was like, hey, I liked what you had to say there. And I looked down and was like, oh, crap, you're the Attorney General for the state of Idaho. And he's like, yeah. And I'm like, yeah, I liked what you had to say there. I'm like, I've been saying this for like 2-3 years that, why is the executive branch making rules and then submitting it to the legislature for approval when it's the other way around? The legislature is supposed to make the statute, the laws of its creation, of the executive branch, and the executive branch is supposed to execute the laws of its creation. See Hale versus Henkel. And he's like, yeah, And
the new Attorney General, who is it? Labrador? Is that who the new AG is?
Is it Raul Labrador?
Well, anyways, he threw out the Sarah Walton Brady case, the playground mom case. He threw it out, refused to prosecute it.
Well, I don't see how he had anything to do with that because
he had thrown it out because he's the Attorney General. If he don't want to prosecute a case, he can make the call.
Well, Attorney General is supposed to be prosecuting state actors. They're not supposed to be prosecuting the people.
Well, yeah, in the corporation, it's different, life. But yeah, that's what Sarah had told me, and that's why they dropped the case. And then she went and congratulated all her attorneys, which I think didn't deserve any kind of congratulation. But I mean, that case was going on for like 3 years. Anyways.
Yeah. Well, remember, I'd already served my, just recently, just prior to that, my 62-page lawful notification letter to the Ada County Courthouse there, the trial court administrator who took, that's you're the agent. Then we went over to the Idaho Supreme Court. Served the Idaho Supreme Court with a lawful notification letter, the big one. And then went over and served the governor and the attorney general. So they were all put on notice. So,
Never underestimate your paperwork. It's amazing how much influence we don't realize what we have. I mean, any of us, one person can change policy. I went in and started busting chops at this local traffic court one time. And I says, I'm not paying you a filing fee when I'm the defendant. No way. You guys drugged me into here and got into a big skiff. And then I sent some people in after me with the same arguments. And if you don't consent with filing that filing fee, with paying the filing fee, they have to take it. There's just no question about it.
This is where you cite the right. Justice is to be without sale, denial, or delay. Why would I have to pay a fee to respond?
You know, some lady told me in the federal court in Ohio. We served. The guy got arrested at the Reawakening tour in Ohio. He got arrested there by some cops because we wouldn't let him scan their ID. I don't know why at a Patriot meeting they're scanning people's ID, but regardless, he ends up getting arrested there. And so we went and filed his Title 42 over there in Canton, Ohio. And I said to the clerk, I says, "What happens if I don't pay this filing fee?" He gave me the money. He gave me the check. I was just certificate of service. I was serving his complaint
Right.
to the court, filing it. And she goes, "Well, she goes, this is the clerk for you. Well, you could file your complaint, but if you don't pay the fee, then I won't give you the summons." Basically, so, they put their stamp on the summons, so you can serve the complaint with the summons. Sufficiency of process, sufficiency of service. And she was like claiming that she holds people hostage, which is it's a violation. You cannot refuse paperwork as a federal United States clerk. You can't do it. I think it's in 18 it's in the US code.
Yeah, is it so in the one
you cannot mutilate or refuse to file or alter. You can't alter a document.
Yeah.
You can't refuse it. But it's interesting, like I said, if you just listen to clerks, man, they'll be running your life and giving you bad info.
I see comment out here. Not to pick on you, Karen. There's a book about the executive law noted on Mark Levine's show years ago. Quit trying to go to somebody else. Just read the frickin' Constitution itself. It's already in writing. Read the instrument of government. Learn it first before you try to go read from somebody else their little dissertation and opinion on stuff. Read the damn Constitution. Read the instrument of government. That's the one that delegates the powers. And until you read that, I wouldn't go anywhere else. There's no need to go try to read somebody else's stuff when you haven't even read the Constitution and have a basic understanding of which branch, how many branches of government do we have? Which branch of government does what? What are the powers and functions of each branch of government? Until you can get that from the Constitution, it isn't going to do you any good to go read somebody else's stuff. That's just a distraction. And not only that, it's just another man's opinion. This is one of the fundamental differences between what I do and what everybody else does out there. I show the letter of the law as it is written. It's not my opinion. These are facts of law as it is written. So there can be no dispute on what it says as it is written. You'll lose that argument every time.
She also made a comment about the January 6th prisoners too, because I always wondered why none of those attorneys for these J6ers filed appeals for motion to dismiss because of failure to prosecute, right to a speedy trial. After 6 months, they should have said motion to dismiss, which they would have denied it. You filed to the appellate court, and if they would have denied it there, then it's a writ to the U.S. Supreme Court.
Yep.
And it's just like the only people that are out of jail from the J6ers were basically the sui juris people. The people who went in self-representing are literally out. There's a few of them. And
motion to dismiss for violating the right to due process of law, the right to speedy trial. Done.
Yeah, and they also did that. That wasn't the first time. People don't know that they were doing that in 2017 to the Bundys. It was already in 2017. It was a year into their being held, in solitary confinement without no right to a speedy trial. And they nobody went and did a writ to have it dismissed. But they did get out of it because of 12 or 13 Brady violations with the prosecution and the whistleblower. I mean, man, that was hell. Yeah. That case was hell. Poor Marcus Mumford, man, got tasered at the end of that trial.
Yeah,
God bless
all
rest
because he
his
was trying
soul.
to demand, where's your warrant to arrest these guys? Well,
I know.
we don't have one. We don't have to show it. Yes, you do.
Yeah, that was a bummer. I like that guy. For I don't like too many attorneys. But then he afterwards, after they tasered him and arrested him, he paid a fine instead of instead of fighting it. Because you know what? When you earn your living in the court and you're an officer of the court, you know what I mean?
Yeah, but
That's
no man is above the law.
I know, but you make your bed, you sleep in it.
But I
You
mean,
know,
if
because he
as
went
he
to
was acting as a man and an attorney at the time, right? Because he
he
was
was,
retained by Evan Bundy
but
to defend him.
but but Larry Klayman was denied the right to present the cases in there because they had blackballed him. He's not in good standing in this court, you know, and so they won't let a real constitutional attorney do it. And because if you're making your six-figure living in these federal courts, a lot of these people are just going to suck it up and take it on the chin, you know, because they're owned by, you know, the bar. They're owned by, you know, their oath.
Mm-hmm. Yes. Huge chimp out here on YouTube. How you doing, brother? Good to see you on here. Read the Federalist Papers after the Anti-Federalist Papers and constitutional debates. Absolutely, and even the Supreme Court has ruled on that the Federalists. Well, I don't know if they put the anti, but you can definitely still apply the Anti-Federalist because that was the true intent behind every single clause of the Constitution. So, if you're going to try to say, Jack Wagon out there in a black robe saying that, well, we have the right to interpret the Constitution, well, let's go read the Federalist Papers and we'll interpret it as the intent of the writer of the document. Not as you want to interpret it, because you're bound to support it. You know, table legs, they support the tabletop. I don't think the legs get to dictate what's on top of the table. They just have to support it. You don't get to interpret the Constitution. You're supposed to interpret the statutes or anything created or done, any actions or conduct under the Constitution. You don't have jurisdiction over the Constitution. You are bound to support it. So
Yeah, huge chimp. He came all the way down to Sonora, California when I did a little meeting with Fred Kelly Grant, and I think we might have been doing. I think we were doing land patents, coordination, and Title 42. He drove all the way down from up north. That's been a while. Anyways, yeah, that guy's he's the seeker of truth right there. I forget his name, but his call sign, huge chimp. Yeah, you know what? Then that's another thing, Kirk. These things are good. These what your show's doing, but when you have a seminar, people really should show up in person and make an effort to get out there.
yeah,
And just, you know, I really feel like there's just more synergy when you're bumping elbows with people, and I almost feel like there's a spiritual impartation when you gather together. I mean, that's even the Bible says, don't forsake the gathering together for yourselves, because when you come into a group, there's a lot of synergy, you know, and it's good. It's good to basically assemble ourselves together. I mean, that's the whole thing of the First Amendment.
yep. You know, this is something that I found in some of the early history of our nation called America here, of our new republic and stuff, and how things were being done even in the 1600s there before the revolution, is that right to peaceably assemble was when the people went to church on Sundays. That was part of the people were part of the General Assembly. And that's where they consulted for their common good and presented their petitions. And people signed the petitions, and then they took their petitions to what? Their representatives, and instructed them to do what they demanded. That's how it's really done. And then another part of that is like if there's any kind of criminal elements to stuff, oh my gosh, that's the common law grand jury. right from the Magna Carta, 25 men right there. You could, right from your own church, the people, because that's what church is the people, right? Or kirk, because that's what my name means, is church. So
Nice.
the people have the right to peaceably assemble to consult for their common good. So this is where you would, the people were to pick the 25 men as their common law grand jury to do a grand jury indictment. So,
Well, here's an idea for a petition. How about petition the legislature to reinstitute the people's common law grand jury in the form of petition? Because we just have puppet
so
grand
here's the
jury.
problem with that. We have to reassemble the General Assembly first. We got to get back to government de jure, and that all gets fixed immediately.
Okay, that makes sense.
Because the people of the General Assembly, essentially, that are qualified electors, those that qualify to run for office, there's certain qualifications for them, and then the people part is where the pool of the jury comes from. The free inhabitants are not part of this, because they're supposed to be free and independent. They're all completely separate from all this stuff, right? So this is how that's supposed to work. Once we reassemble government de jure and the real people have assembled the General Assembly, which is the first branch of government. Some people like Scalia out there in that one case that talks about that it's essentially a fourth branch of government. Well, I haven't found that particular part in that case that's being cited there, but hey, I've only looked at 4 different versions of that case file, so at least I've researched and tried to read it. But in my mind, it has to come first, so it's the first branch of government. Number 2, the General Assembly is the one that creates the Constitution itself. So how is it not the first branch of government? If all political power is inherent in the people, and that's the sovereign body politic to create the instruments of government, because what it says, that to secure these rights, governments are instituted among men. Oh, of the people, by the people, for the people. That's where that comes from, and that's straight out of Law of Nations, by the way. Book 1, Chapter 1, Section 3. And Preliminaries, Section 1, 2, and 3. So, yeah, this is the law of creation, right? You got God as the sovereign, creates mankind, and he endows mankind with sovereignty. And sovereign is the creator. So when the people come together, this is the first fundamental principle of one of the 6 primitive laws of nature, is when man is properly organized, he knows the difference between moral good and moral wrong, moral evil. Okay. So when are the people going to peaceably assemble, or when are we going to come together here and reassemble our government de jure and claim our powers and alter, reform, or abolish anything at any time we deem it necessary, including the entire Constitution? Because all these constitutions now are all corporate Ponzi scheme, corporate charters, essentially, since 1871. When are we going to do that, folks? Crickets. That's the problem we have out here. Nobody wants to really step up and do this, which I get it. I mean, too busy doing other things, and not as an excuse, but no, literally too busy trying to survive. And that's been done on purpose, right? If we're getting to the point where, if there's any of these real families left where you have a husband and wife and kids that are living together, both of them are having to work just to frickin' survive and put food on the table, and it's getting more and more exponential where, crap, somebody might even have to start taking a second or third job.
I did a calculation from 1950 to right now.
Oh,
The dollar is worth 1/24th of its power from 1950. It used to be, you used to be able to buy a brand new car for like $600 or something. I mean, it's
oh
just
yeah,
absolutely insane.
yeah. So the almighty dollar is going down, by the way, and it may end up being down here next month.
You remember hyperinflation in Germany? I don't even know if we might even exceed hyperinflation. You know, that's which means that was a depression. Hyperinflation was in Germany. I think the guy who worked at a hotel, the bellboy, was investing in silver. So when they went into hyperinflation, the bellboy, the guy was carrying all the luggage, ended up buying the hotel because he had silver. And that's being manipulated big time right now. Jeez.
Oh yeah,
Lawful money, right?
yeah, lawful
And
money,
these guys,
gold and silver.
these guys don't want to even recognize lawful money. It's crazy.
Well, again, that's part of the third and final bankruptcy of 1933, when they took all the gold and silver and they started handing out fiat currency. The Federal Reserve, right? The meeting of Jekyll Island in 1910, and then, the ones that were opposed to the Federal Reserve in doing this was on the Titanic. And they were killed.
Yeah, there was a lot of manipulation, like the whole Johnson Amendment. Kennedy got to talking about unity. Kennedy was the first Catholic president of the United States, and the Catholic Church had a lot of pull in the 60s, and they all voted him in. As soon as they murdered Kennedy, Johnson come in with the Johnson Amendment, taking away the political voice of the church, saying, I'm going to give you a benefit and a privilege in a 501c3, which you'll be tax exempt, which you already had it to begin with. You know what I mean? Here, it's just like the 14th Amendment. Here, let me give you something, but take everything away from you. And so that's why a lot of these 501c3, that Jesus Christ ain't the head of their church, the Internal Revenue Service is. And they give unto God, like marriage. Give unto God what belongs to God. Don't give unto God like your church organization. Give it unto Caesar. Get a privilege. Pay a fee for it. And then be subjected to putting a muzzle on your mouth. It's just, the churches, there's not a whole lot of leadership in our entire country right now, Kirk. Who do you look at as someone who's a real example of a leader? And the only person in this country who's able to mobilize anything is DJT, man. As much as people don't like his style or say he's a plant or this or that, this man is mobilizing people like never seen in my lifetime.
Who's that?
I mean, Donald J. Trump, man.
Oh,
I mean,
yeah.
I mean, Ronald Reagan had a lot of influence. I think Trump has made an impact like times 4 what Reagan did, just in mobilizing the base.
At least waking people up, getting people to come together. Now, when you guys go to these rallies and stuff, start turning to each other, and before you leave, make some connections and like, hey, let's come together like this on a regular basis.
Yeah, this isn't about Trump. It's about we the people. I mean, that's out of his own mouth. So
all political power is inherent in the people, not Donald J. Trump, folks. Now, Trump's playing his part, working with the military, and I've already gone down all this stuff many, many, many times, showing the proclamations and executive orders and, laying this stuff out since 2017 when this stuff was started. I've been laying this out for years. So, the fact is his first day at the inauguration, his speech there, one of the first things he said, I'm putting the power back into the people's hands. It is up to us. This goes right back to, how do we wield that power? Well, we have to reassemble government de jure. We have to assemble the General Assembly first.
And here's the thing. People want to bitch about Trump. Should it matter whether the president is Joe Biden or Donald Trump? It shouldn't matter. It all goes back to what you're saying, the people. So I don't care who's elected. They all swear the same oath. It's all the same oath. And it's public servanthood. The president really shouldn't have any of that power to begin with. So I'm not worshiping Trump. People can criticize him or criticizing Biden all they want. What the hell are you doing? We can criticize everybody.
Yep.
What are we doing for liberty? Because what did Thomas Jefferson says? Liberty begins with you. Like, what are you doing about liberty? Donald Trump is, like I said, he's just mobilizing people. You
Yep.
know, Biden or Trump, neither one of them should have influence over what our rights are because they didn't give us our rights. God did. So let's exercise our God-given rights, buck up, and
Yep.
if you're going to let a bunch of satanic pedophiles roll over you while you're complaining about Trump or complaining about anybody else, then get off your ass or shut up.
Yep.
Sorry, I mean, you know what I mean. I wear the hat, but it's a symbol. It's all it is. It points
Yep.
to America being great, not about Donald Trump or his attitude or his habits or whatever the crap that he says. I don't agree with everything he did, but he's not my savior.
Right. We're running out of time here, folks, because we're getting into basically the third generation of educating these kids about critical race theory and all this stuff. And it's getting to the point where, people my age, our age, and above are the only ones left that have any kind of sense left. Morals. And this goes back to the Rules for Radicals by Saul Alinsky. How to destroy a society is to take the morals away. So we're it, folks. There's we're
not going to vote, and we're not going to vote our way into liberty either.
Yeah, no. We have to have a frequent reoccurrence to fundamental principles. We got to have that when man is properly organized, he knows the difference between moral good and moral evil. Okay, that's the problem where we're at today is they don't even know the difference between good and evil anymore. Because they've been screwed up with the V word. And I'm not, the stuff in the vial there. Okay? All of them from get-go. They're all garbage. Ain't not one of them is any good. Okay?
Crap most stink.
It's all poison. By evil design. Okay? And then the pharmaceutical drug industry. Okay? It's all synthetic crap. None of it's natural medicine. Medicine comes from herbs. Right? That's medicine. Drugs is the pharmaceutical, and it's all manufactured. It's all made. Right? It's synthetic. They're trying to mimic some things, and our body can't accept it. And there's another evil design. Okay, that all that does is cause more problems, and then you end up taking this one for this one, and this one for that one, and that one for this one because it causes this and this, and it's just a never-ending scheme to kill the people off. That's what it's all about. Okay, so then we have all of that, and that's destroying, coming in and taking the medical stuff, and getting away from real medicine, and doing pharmaceutical drugs, and the education. Right, that's part of that. One of there are 8 different categories under the Rules for Radicals, and is by Saul Alinsky there. Take over the education, take over the medical, take over the money. That's the biggest one. Okay, all these things have been done in slow increments over time, going even clear back to 1787, 1789 with the first Constitution. Now, I want to make this point real quick. President is a member of a corporation. Governor is the head of a country. Think about that, folks. For the first bankruptcy. That's right. And gee, when did the first bankruptcy started to come to an end there? In 1861. Gee, what happened in 1861? A civil war? Oh, it's about slavery. Well, if 1861 Civil War was about slavery, then why were we still dealing with slavery in 1964? Why did the statutes at large start in 1774, 1794, something like that, abolishing slavery?
People failed to miss the big bullseye in right in front of their face. The Confederate flag has a big X in the middle. Hello, Amendment 10, state rights. I mean that's where it was at. The states were divided. I mean, slavery could have been an issue, but do you see the big X on the Confederate flag, right bullseye where all the stars are at? I mean, right within there. I mean, it's just right. There's clues if we'll look.
Yeah, we just we need to hang in there, folks. But the most important part right now is we really need to come together. We really need to pick up the law, our rights as the law, and start putting these people in their place. And the bigger picture again is the reassembling government de jure. And the folks over there at national-assembly.net is the ones that are the legitimate ones that are doing this right, that are working with the real military behind the scenes, okay? They're the only legitimate ones. Okay, I've been down this rabbit hole stuff for years looking for this stuff, and I finally found the legitimate ones. And we're getting a lot of interference and a lot of infiltration trying to stop this, because why would we have so much infiltration and try to stop what we're doing if we're not the legitimate ones? The ones that are actually in contact with the military. Just saying. Okay? Trust me, I have been down the rabbit hole looking for this stuff since I found Carl Miller back in, what was that, 2012-ish? Okay. He
Carl Miller,
about that
man,
Project Blue Book that he was pulled aside and the military was talking about doing this stuff, trying to teach the people about our Republican form of government, because got to do something. Got to get the people educated, because if you don't have the knowledge, we ain't got no power. That's just the reality of it, folks. So, I'll pull that up on the screen here just real quick, just to kind of direct people that way.
And, when people do file their paperwork and go after these people, I mean, this is the first step of getting people out of the way that shouldn't be in positions of power.
Yep. I mean, there's definitely some stuff that's been put in place and things have been altered because of what Donald J. Trump has done.
Are you familiar with Lee Dundas, Kirk?
Lee Dundas. Why does that sound familiar?
Dundas. I think she's one of Trump's attorneys, one of them.
Huh.
She was on a show the other day, and she's saying, you know what, she was claiming, she's a bar attorney. She says, us attorneys need to start thinking outside the box and doing different things that we've been doing. I mean, she recognizes that, well, even as an attorney.
Psst, the bar's going away. Just saying.
Yeah, what do you call a lawyer with an IQ of 70? Your Honor. At least a state court judge, anyways. Give the federal courts judges a little.
Why do they wear a black robe? Do you know?
I don't know. Is that some type of satanic ritual or what?
Absolutely. It's from the Black Pope from the Roman Catholic Church, Crown Temple Bar. You know that there's a black pope and a white pope, right? And I'm not talking about skin color. I'm talking about the robe he wears.
I usually don't rise before the because it's not a law, it's a rule. Just like take your hat off. Anyways.
All right, so here's the website, national-assembly.net. Okay. And right here on the conference call info, This will give you the info to be on there for Thursday nights. Okay, and it's at 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. Now you can download free conference call for your smartphones, either your App Store or the Play Store. You can download it on your desktop or laptop. Okay. Or you can just straight dial in. But I highly recommend getting the app and installing the app, because it makes it a heck of a lot easier to use. Instead of having to sit there and dialing *6 and everybody hearing your deet 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 every time you hit it.
I know I was on that one time. I was like, what's going on?
Yeah. So there's some video here, YouTube videos for tutorials on how to do it for your smartphone or for your desktop. Okay. And then right here, join the online meeting. You can click on that from your desktop, maybe even from your phone even, and do it through a web browser. Okay. But if you have the app, it works so much better. Okay. That'll get you in there. The first part of the session is the business part of it. And then the second part is the general discussion and education. Q&A, question and answer. So lately it's been pretty darn good over there. Oscar's been teaching on that citizenship manual that, gee, I don't know where that came from the military. And this last Thursday was actually a pretty good one. But yeah, this is it, folks. And if you're new, you can start here. Where's that? Resources. You can start here under the resources. What's the current situation? Where we are? Where's the people? Where are we, the people? Okay, here's some public notices. The 1638 Fundamental Order, which is, in a sense, where the General Assembly comes from. There's the training manual 2000-25 or -25. Okay. Where was the... Oh, there's some his hardline. Jason, he does his hardline podcast there. Those are some good ones to listen to. Okay. Here's the forums and blogs if you want to get in there, but you'll have to sign up. Assembly, is this, where's the videos at?
I saw them come up at one of the other boxes that you hit. There were videos.
Oh, here they are. Okay. Man, I stopped at the 1638 Fundamental Orders and skipped right over it. So, assembly supporting videos, that's a fairly good start there. It's kind of right here. Resources, kind of just go down this line. And then here's your 10 steps to an assembly. Here's their handbook. Okay. This is basically for the Michigan and the Michigan stuff that originally started all this stuff. Okay, this is where Carl Miller was out of, and Carl Miller was a part of this stuff way back. Okay. And yeah, National Assembly, this is all free stuff. Okay. So that's national-assembly.net. And this is just this is not an actual National Assembly, that's just the name of it. Just like Kirk's Law Corner LLC, they're providing education as a business. Okay? We can't have a National Assembly until we have all of the states assembled. Because how are you going to send delegates from a state to represent a National Assembly if we don't have the states assembled? Completely illogical. Okay, folks? And get yourself hooked up there with people from your state. I've got stuff going on. Well, no, I wouldn't say going on, but KLC American Patriots on Telegram. I've got it broke down into individual states, but I kind of just gave up on it because it didn't seem like anybody wanted to do anything. So, unless the people really want to come together and let me know that you really want to do this, get you in contact with the people from your state. All right, folks. So I think, well, we went for 2.5 hours tonight, brother.
Yeah, right on. Well, thanks for having me on, Kirk. I got about another 4 or 5 hours of work myself tonight. Got to get on Pacer, see what the activity is going on all these federal lawsuits I'm consulting on, and it's amazing how slow everything moves, man. I think people got to mentally prepare when you're going into battle, and if you don't, if you don't have the knowledge and you haven't read up, and you're going to try to jump into this, you're not going to have the stamina and you're not going to have the endurance that it takes to follow through to victory, because he who leaves the field of battle first loses. And I see many people that grow weary in the battle. And part of not growing weary is, like you're saying, Kirk, assemble yourself, get together with people, find people in your area. If you have to have a Bill of Rights class or a Constitution class in your living room to get people together, then do that. That's what your part is. You shouldn't be in this battle fighting by yourself, like you said, Kirk. They got everybody isolated, and that's been the goal. Keep us isolated. All those shutdowns, they never seized one gun and shut the whole country down. I mean, that's why we need leadership in this hour. There's really not a lot of leadership that I respect in or out of the church, in or out of government. I just don't see a lot of it. So I guess it's up to us. New expression. We are the new expression of the old forefathers. This is our watch. That they did their watch. They pledged their lives, fortunes, and sacred honors. And you got people afraid to get a ticket, or they just want to go do activism, and they can't even get themselves out of jail in time properly, or successfully defend themselves with the law. I mean, we have to study to show ourselves approved. And we also have to put our big boy pants on and do this stuff. It's called patriot shit,
Mm-hmm.
And patriotism isn't supporting the military and hanging a flag. It's fighting tyranny. That's what patriotism is. And there's plenty of tyranny in every neighborhood. So
there's no shortage of that.
No. But anyways, Kirk, yeah, I got to get back to work. Thanks for having me on, and I always enjoy hearing you teach the law, brother. I really do.
Well, thank you. I love you too, brother. This is some awesome stuff, and we need to come together, people. We need to bring unity. We have to come together. And, this is... If we don't do this, we're going to lose our republic. We're going to lose God-given rights. It's we have to claim it, right? We have to bring it forth. We have to come together in sufficient amount of numbers to say, no, we believe in God. We believe in these rights. These are God-given rights, and we want a moral society. We don't want gay marriage and all that stuff, right? We want our religion, essentially, our morals, principles, to be sacred and left alone. And we don't want immorality in our society. And if we don't have enough people to come forth to stand on those basic fundamental principles. Now, I'm not saying that there are people out there that you can't be gay. Keep it in the private, right? Just not out where everybody else can see it. You know, that whole keep it in the closet type thing, right?
There,
That's
there's
between
no
you and
reason to
God. But don't
there's
put
no
it in my
reason to
face.
talk to
Don't try to cram it down my throat.
little children should not be hearing about sex, period. It's called corruption of the morals of a minor, even under
Oh
the
yeah,
stupid statutes.
yeah,
You know, you could cut the tits off of a 12-year-old or a penis off of a 12-year-old boy, but yeah, but according to these people, they're sick,
yeah.
and
That
and
violates
and
one of
it's
the.
child abuse. And this whole thing in California, they're saying if you don't allow them to do that, you're abusing, and we're going to human trafficking your children over to a bunch of morally depraved people. And like you says, they have a right to be morally depraved, but not by for somebody else's children. And it's the old castle doctrine. You're the king of your castle. Nobody tells the king how to raise his own kids.
Yeah,
It's outrageous. And all this fear, Kirk. It's like everybody's afraid of being arrested, man. I've seen you in cuffs before. You didn't give them your name. I was at a courthouse walking through and got into one of the gatekeepers at the metal detector. He put handcuffs on me. I'm like, "Are you high?" I'm like, "If you take these things off right now, I'll give you a break." He's like, "What do you mean you'll give me a break?" They had 3 deputies cornering me. They didn't even get my name or why I was there, but I got all their names and all their badge numbers, and I told them I was going to pull their oaths and get their good face surety bronze and get their supervisor's name, addresses, and sworn and subscribed oath of offices. And these guys' heads were spinning, man. It's like you don't have to be arrested. If you're dumb, you'll get arrested. And if you do get arrested, well, evil prevails when good people do nothing. You don't think Martin Luther King never thought that he was going to get arrested? And this guy went out peacefully assembling. He was afraid, but if you pledge your lives, your fortunes, and sacred honor, at least you have honor that you're doing something about it. And to be silent in this hour, do nothing is just cowardice, bro. There's no other way to put it. I'm sorry. And I see more women out there right now, like 70% more women at these seminars and liberty meetings. 7 out of 10 people are women right now. And in all the meetings that I travel across the country and see, the mama bears are stepping up. So what did Will Ferrell said in that Ricky Bobby movie, Talladega Nights?
oh,
Oh, sir, excuse me, I didn't know that you had your balls experimentally removed. He goes, it's in the Geneva Convention. With all due respect. Sorry, I got to throw in some humor in there. It's not in the Geneva Convention, but that's a Will Ferrell line, But
yeah, yeah.
who knows? We have to stand up. I mean, if we don't, if there's nothing worth fighting for, then just lay down, I guess. Just, bend over. Your name will be converted to bend over if you're not going to be a patriot in this hour, a man. And anyways, so I got no respect for cowards, man. I don't, bro. I don't.
Yeah.
Not that I'm judging somebody. I'm better than anybody else. No. I might make mistakes, but you know what? I just can't. When they cross the line, when I don't have kids, they're going after children now, man. What more? What more do they have to do?
Yeah. Hey, over here on Telegram, Hal Brown, I sent you a private message on Telegram, just so you know that's really me over there.
But anyways, Kirk, I got to get back to work, brother.
Yeah.
I look forward to coming on again, or I gotta hear more about some of this stuff. It's all good, man. Every time.
Yep.
Appreciate you, brother. Much love, man.
Yep. God bless. Thank you for being here, and we'll catch up another time.
Thank
you. All right. Good night. All right, folks. That's going to be it for us tonight. And I hope you enjoyed our show here tonight and education that we brought forth, and trying to teach you guys some remedy and relief and what you can do following the letter of the law. Okay. Other than that, I have my private Wednesday night workshops on Patreon, where I go into a little bit more detail there, and you can come right here. Right on the website here, kirkslawcorner.com, will get you right over there to Patreon. That's tier 3. This one right here will take you to it as well. Okay, this one right up here will take you to it. This one will take you to the Telegram channel, where people over here are watching live on Telegram, which I'm pretty much way more active on Telegram than I am any other social media right now. That's where I do a lot of my sharing type stuff. I still have my Facebook page up and going. I share some stuff over there, but documents and that kind of stuff and good videos, good stuff that may get banned or whatever, that's all going to be over here on Telegram. Okay, folks? So I want to thank all those that have been supporting over there on Patreon, those in Wednesday Night Workshop. One-on-ones, that's tier 4. If you want some one-on-one time with me, that's tier 4 there. Tier 1, tier 2, that's just to help support what I'm doing right here, right now, for free. Okay, it's just considered a donation to help support me. Pay the bills that this is what I do. I've pretty much dedicated my life to this because I can't focus on anything else. All right, so I believe this is what God has called me to do, so this is what I'm doing. Can't seem to focus on anything else. So that's how you get to the Patreon channel there, and we may end up doing a special course with Tony Pellegrino and myself. I know we gotta talk about it, plan it, and figure out how we're gonna set that up. So, but thank you, Brother Tony, for coming on tonight. Everybody, thank you for the likes, the follows, the shares, and your love and kindness, and your support, and your prayers. And I'm going to be asking for a little bit of special prayer for this upcoming week, as I will be doing a little bit of traveling, and I'll let that a little bit cat out of the bag when that all goes down, and when I get there and get all set up and all that good stuff. Okay, so it's gonna be a good time. But I greatly appreciate any prayers for the full armor of God, and keeping myself safe, and yeah, good times. All right, so God bless, and again, thank you all for your love, your kindness, and your support. Likes, follows, and shares. We got to get the people educated. All right.